Welcome once again to Lehto's Law. Here's Steve Lehto.
This is, without question, the most requested topic of all time on my channel. I've said that before, but those previous stories got nothing on this one. This one blows them all away. Crazy story out of Missouri, and I am going to read to you directly from the opinion of the Court of Appeals, widely reported in numerous media outlets. But it appears that Geico has been ordered to pay a woman a few $1,000,000 because she says she caught something from a man that she was physically involved with in a car insured by Geico. And now Geico disputes that, but as of right now, the Court of Appeals says, well, this multi-million-dollar judgment is good. And Geico has filed another action on this in federal court. We'll get to that in a second, but let's understand what happened first and why everyone is going so crazy over this case. By the way, all I can tell you about this lawsuit is it is initials MO versus Geico. And due to the sensitive nature of the underlying claims, the litigants used their initials only in court. So it's MO versus Geico. And this is the opinion from the Appellate Court in Missouri. Appeal from the Circuit Court. Government Employees Insurance Company, Geico, appeals the judgment of the Circuit Court of Jackson County, which confirmed an arbitration award finding against Geico's insured and in favor of MO. Insured and MO were in a romantic relationship. And yes, I know that sentence right there reads like a bodice ripper. It's so romantic. It's like something right out of Romeo and Juliet. Insured and MO were in a romantic relationship. But you have to understand what happened here. So first, the two people had encounters in the automobile. I'm going to tap dance around this because I want to keep this story PG so that my entire audience can enjoy it. Although no videos I make are aimed at children, just so you know that. But they had adult encounters in the automobile. Sadly, nowhere in these stories did I ever see what kind of car it was. Because that does play into, those are key facts, my friends. If this was happening in a really small import versus a gigantic SUV land yacht, very, very different skill sets that go into that. But I guess on some other level, it's not that important. Because she says after they had the encounters in the automobile that she caught something from him. And again, that is the kind of thing that you can catch from somebody when you're having these kind of encounters, whether in an automobile or otherwise. But she says that because it happened in an automobile and there's insurance on that automobile, the insurance ought to cover her because she got injured in his automobile. That's the entire underlying claim. Now, one thing you should know, and a lot of people don't know this until they stop to think about it, or they go, oh, that makes sense once you point it out, is that many people say, well, I have insurance on my car or my home or an event. And so if somebody gets injured, the insurance pays for it. People often think of that as insurance pays for the injury. But there's actually a more important thing that people are skipping right there. The insurance also has a duty to defend the insured against the claim in the first place. So that if someone sues you and you have insurance that covers the event, in most states, the insurance company doesn't just stand idly by and say, well, you get sued, and if you get hit by a judgment, send us the bill, we'll pay it, we'll cut a check. No. Number one, they've got a duty to defend you, but number two, they have a desire to defend you, because if you don't defend yourself and you get, say, defaulted, or you get a, $5.2 million award against you, well, we might have been able to step in with our high-powered attorneys and get that lower or not at all in the first place. Because who's got the best incentive here to fight this claim? And that's the insurance company. So the question is, where was Geico during this? Not during the backseat action, but during the litigation. So the insured and MO entered into an agreement pursuant to state law that allows them to arbitrate the claims. So Apparently in Missouri, if you want to, you can file a lawsuit against the insured, or you can enter into an agreement to arbitrate with them. So the arbitrator found the insured did negligently cause the injuries to MO and awarded her $5.2 million in damages. Then MO took the arbitrator's ruling into a court to have it converted into a judgment that would then be something they could collect upon. At that point, Geico moved to intervene. They said, okay, we want to get involved now. Horses left the barn. They want to get involved. And MO moved to confirm the arbitration award. The trial court granted both motions and said, yeah, Geico, you can get involved. And I'm going to grant the motion to turn that into a judgment. Why don't you just pay the judgment? We can end this now. So Geico appealed, asserting that the trial court made mistakes in confirming the arbitration award without giving Geico a meaningful opportunity to defend its interests. For the reasons stated below, we affirm, meaning that they turned down Geico's appeal. And the question is, did Geico have a meaningful opportunity to defend its interests? So keep in mind that an insurance company has a duty to defend you and then to pay based on what the coverage is and all that stuff, right? So we're going to go over the facts briefly. In November of 2017, MO and insured began a romantic relationship which often apparently involved a car. Effective at that time was an automobile insurance policy issued by Geico to insured on that particular car. On February 25th, 2021, MO submitted to Geico a petition she intended to file against the insured and made a settlement offer to resolve her claims against the insured for the applicable limits of the Geico policy of $1 million. So she contacted Geico and said, I am going to come after your guy for this money, and I understand you insure his car. Maybe you should just pay this. So it appears that Geico did get notice of that back then. The petition attached to the settlement offer alleged that during November and early December of 2017, which, by the way, is not romantic time in Michigan when it comes to cars, but maybe in Missouri, it's cold out. So the insured and MO engaged in activities that adults do when they love each other very, very much. And that was happening in the vehicle. And during those encounters, insured negligently caused or contributed to cause MO to become ill with something that you could catch during that time. So they didn't take proper precautions, let's say. And he neglected, and this is the allegation, he neglected to inform and or disclose to her that he had something she could catch by doing what they were doing in the car. So she alleged that as a result of negligence, she incurred and will incur past and future medical expenses, as well as past and future mental and physical pain and suffering. On April 7th of 2021, Geico denied coverage, and they said no to the settlement offer. So they denied coverage, we're not covering this, and we're not going to give you the $1 million you've requested. Geico also initiated a declaratory judgment action in federal court to establish the parties' rights and obligations under the insurance policy. We often call that a DEC action, DEC, D-E-C, short for declaratory. And you're asking the court to, in essence, make a ruling on a very important matter of law. And insurance companies will often bring DEC actions, and they'll say, we want the court to rule right now whether or not our insurance ought to cover this. And if we don't think it should, we'll bring that now so we don't have the duty to defend because we don't cover it. So on March 11th of 2021, MO and insured entered into a contract to limit recovery to specified assets and arbitration agreement pursuant to state law. State law says that you guys can have a arbitration on this matter. And on May 17th, the two arbitrated the claims, and the arbitrator issued his findings, conclusions, and award. The award first described procedural aspects of the arbitration, including that the insured submitted a statement detailing his defense. Both parties presented opening statements. Insured was given the opportunity to cross-examine the witnesses and elicit testimony for his own defense. Insured submitted as exhibits internet articles discussing the illness we're talking about. She requested an award of $9.9 million in damages in her closing argument. And in his closing argument, Insured disputed that he was aware that he could have actually given her what she got, but, he didn't know that. The arbitrator then determined that there was, in fact, activity in the insured's automobile in November and December 2017, which occurred in Jackson County, Missouri. The activity in insured's vehicle directly caused or directly contributed to cause her to be infected. Insured knew he had been told that he had issues there. Insured should have disclosed his diagnosis to her before they had that activity, and that insured was negligent and is liable for causing her to contract this. The arbitrator found that an amount that would fairly and justly compensate her for her damages and injuries is $5.2 million, and entered an award in that amount in favor of plaintiff against the defendant. And the defendant, of course, is the insured. On May 24th of that year, MO provided written notice to Geico that she and insured had entered into an agreement pursuant to state law. And the following day, MO initiated the action by filing her petition for damages in the trial court. On June 10th, Geico discovered the existence of the lawsuit by monitoring CaseNet. And they saw a lawsuit pop up with their name on it, so they then jumped into action. And on June 18th, they filed a motion to intervene. On June 22nd, MO filed a response to that motion and a motion to confirm the arbitration award. In her motion to confirm the award, she asserted she and an insured had agreed that after an award is issued, she will immediately seek to have the award confirmed and reduced to a judgment, and that neither side will seek judicial review, etc., etc. Geico filed a reply in support of its motion to intervene, and on July 2nd, the trial court granted the motion to confirm the award and entered judgment in favor of MO against the insured in the amount of $5.2 million. The trial court adopted and incorporated the findings and conclusions of the arbitration award and stated that the award was attached to the judgment as Exhibit A, and although it wasn't attached, it later got made part of the record. The court likes to point these things out because mistakes were made, but they were minor. On July 30th, Geico filed a motion for leave to conduct discovery, a motion for new trial, a motion to vacate the arbitration award. And in the latter two motions, Geico asserted that the arbitration award and the judgment should be vacated because the award was procured by collusion, fraud, and undue means and was contrary to public policy. Now, here's the deal. Courts like arbitration because if you arbitrate a case, it gets resolved quickly and it gets resolved outside of the courtroom. So if I'm a judge and there's parties in front of me that want to have a trial, I go, oh, great, I got to schedule a trial. If they go, Your Honor, can we arbitrate? Both sides agree to this? Sure, go outside and arbitrate. They go find an arbitrator. They arbitrate this. They bring back into court a piece of paper and they go, here, we've resolved all our issues. Just enter this. We enter that. And arbitrations are very rarely disturbed. That is, you cannot generally appeal an arbitration unless you can show collusion, fraud, or undue means. So obviously, if you and I arbitrated a case and I won, and you later found out I flipped the arbitrator a couple $1,000s to get a good ruling, well, that would be some sort of collusion, fraud, or undue means, right? Okay. And likewise, if you discovered that the arbitrator was actually related to me and none of us disclosed that to you, that might be a problem also. But generally speaking, you cannot appeal because you think, oh, the award is unfair. And we've talked before about how if you get a crazy award from a jury awards you $1 kajillion. Okay? You can appeal that and just say that award is just beyond the pale. $1 kajillion? It's like one with a bajillion zeros after it? What is that? And that can get overturned on appeal in a court case. The question is, if an arbitrator issued a ruling for $1 kajillion, well, was it arrived at by collusion, fraud, or undue means? If not, it might stand, despite the fact we're not quite sure what a kajillion is. So they said it was contrary to public policy and contrary to the law. And they said it was also a bunch of other problems. So Geico now appeals, claiming 3 different errors were made by the trial court. And just to let you know, the court strikes down all three of them. And I'm not going to get heavily into this because this is about a 15-page opinion. But in its first point, Geico asserts the trial court made a mistake by confirming the arbitration award because law gives interveners the right to meaningfully participate in the case, in that Geico was prevented from developing facts and arguments pre-judgment. But you'll remember that Geico was told about this woman's claim before the arbitration. They told her, "We're denying your claim. We're not going to pay you anything." So the arbitration proceeded, and then she brought the arbitration award to court and sought to have it certified and entered by the court and turned into an official judgment. Geico then said, "We'd like to intervene right now," and the court said, "Fine, you can intervene right now." The problem is what they wanted to do, which was develop facts and so on, that time had passed. So being allowed to intervene is one thing, but once you get involved, you can't then reset all the shot clocks and go, okay, we want to go back to square one. No, you intervene at the stage at which the case is at. And if you wanted to get involved earlier, guess what? You could have gotten involved earlier. In the second point, Geico asserts the trial court erred by confirming the arbitration award because state law provides a right to challenge arbitration awards, in that Geico was prevented from raising and developing its reasonable good faith arguments about the award's invalidity due to fraud, collusion, undue means, and unreasonableness. But once again, Geico's argument rests on the timing of the judgment. Geico says it had a right to challenge the award prior to entry of the judgment. But without actually bringing in evidence as to what they think is wrong with this award, you can't just go, well, we don't like it, overturn it. That's not how the courts work. Geico argues the trial court ignored a section of the law that says parties have 90 days from receiving a copy of the award to apply for vacation of the award, that is, to vacate the award, and that the trial court deprived Geico of its statutorily guaranteed time period in which to challenge the award. But Geico was not a party when she applied for confirmation of the award, and it was not a party before that. They were simply an intervener at one point. So the law that talks about what parties can do, they weren't a party. They weren't a party to the lawsuit. It was MO versus the insured. Neither of them are Geico. So they lose on that point. Point 3, Geico asserts the trial court erred by confirming the arbitration award because the state and federal constitutions provide a party with rights to defend its interests, in that Geico is denied the right to litigate its interests before judgment is entered against its insured. And they specifically talk about the due process clauses of the state constitution in Missouri and the federal constitution. Geico's claims of constitutional deprivation presume that Geico is denied the opportunity to defend its interests relating to these claims. But Geico did have the opportunity to participate and defend its interests, including the ability to challenge liability and damages by entering a defense of the insured. Okay? So, like I said earlier, when they got the claim from MO that says, I was injured in a car you insured owned by this guy, I demand payment. They could have said, we ain't going to pay you, we'll see you in court. And they could have gone to court and defended it. Or when the guy said, I'm going to enter into arbitration, they could have shown up and represented him at the arbitration and offered him a defense there. But they didn't do that. So if you have the opportunity and you pass on it, that tends to hurt you. Geico did not take advantage of this opportunity and instead denied coverage and refused to defend insured. Moreover, Geico initiated a declaratory judgment action in federal court seeking a determination as to its obligations under the insurance policy, and that federal action provides yet another forum in which Geico may defend its interests. The insurer has a forum by declaratory judgment action that affords the insurer full scope to protect its interests against the contention of coverage and hence liability for the judgment. So they shot down all the appeals, and as of right now, this woman, MO, has a judgment against the insured for $5.2 million for what arose in the back seat of a car, presumably. So I know people right now are saying, Steve, this is crazy. This is insane. How did this happen? Well, you have to understand something. that if you read the policy of insurance for your car, which very few people ever actually do, and read the section of what it covers, it's going to be a lengthy laundry list of stuff they cover, but it's going to say things like injuries arising from the operation and use of an automobile, blah, 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 blah. And it's very, very broad. But then there'll be a bunch of exceptions. And it's going to be the obvious stuff that people had thought of. Apparently, nobody had thought of this yet. Right now, at Geico and other insurance companies, particularly in Missouri, there are teams of people writing up new policies with an exclusion saying this is something we do not cover. We do not cover this. If you catch something in this car, that ain't us. But I can tell you that you'd think, well, how complicated can this really be? And I've seen lawsuits where people have had to litigate things like a passenger is stepping out of the car and gets their foot caught on the edge of the floor there and stumbles and face plants on the ground, and they sue because they said, I was climbing out of that car, I was injured due to something happening with this car. Therefore, it's an injury covered by the insurance policy. And as you can imagine, people can argue back and forth on that all day long, and courts of appeal are faced with these kinds of questions, saying, but is that an injury that's covered by the policy, or is it excluded by the policy? And there are no bright line answers on a lot of this stuff. But apparently, nobody had thought to put in the exclusion for this. So the mistake was made by Geico at the very beginning when MO contacted them and said, I have a claim against your insured for $1 million. Here, take a look at it. They looked at it and said, oh, we don't have to cover this. This is not a coverage event. This is not something we have to defend against. And they said no. But they could have said, well, since you are alleging it happened out of the use and operation of an automobile insured by somebody that we insure, we will offer that guy a defense. And they could have come into court and at the very least filed the deck action asking if in fact it's something they are required to cover. And if the court said, yeah, you have to cover that, then they defend the guy. Would you get a different result? I bet they would have, but they chose not to defend it. And so that's the danger of, that duty to defend is something they should take up more often than not. But here they chose not to, and I think they just assumed this is crazy. We'll never get hit for this. Well, famous last words. Joey sent me a note and said, Steve, they should have opted for the interior protection plan. I had a note here to say that. However, one thing I should tell you is that Geico does still have an action in federal court. It was referenced by the Court of Appeals in their opinion. And Geico has asked a federal court to rule on this issue. The question is, if the federal court says they don't have to cover it, but a state court has already ruled and said they have a judgment against this guy, and there's going to be a fight there, I'm sure, as well. But technically speaking, a federal court could say there's no coverage for Geico, therefore the woman's $5.2 million judgment is simply against the individual, and Geico doesn't have to pay it. So that's what Geico is hoping to do here, and it still could happen. So the headlines about Geico paying $5.2 million to women, that's jumping way, way ahead of things here. That's not quite the case. I would have to tell you another thing, though, about arbitrations, is that you go to an arbitration and you're rolling the dice because you know that there's most likely never an appeal on this. I have never in my life had an arbitration overturned, changed, or modified by a court. Never. And I've done a bunch of arbitrations. I've also never seen one. I'm sure it's happened, but I've never seen it happen. It has to be very, very rare for arbitrations to get overturned. But if you go in front of an arbitrator, the arbitrator decides the issues of law and the issues of damages, if any, and makes a ruling, and they act as if they're both the judge and the jury, and they enter a final ruling. That is then something you take to court and get turned into a legal judgment. And so they can give you exactly what you ask for. They can cut the baby in half, as they say, or they can go in either direction, and assuming it's not insane, it'll get upheld. I can tell you I've actually had an arbitrator award less than either side asked for, and I've also had an arbitrator award more than either side asked for. And I'll tell you the second story because that's the interesting one. I had a case where a client of mine had an open and shut case where somebody owed him a fixed amount of money. And let's just say $10,000. I'm making up numbers here, but I don't remember the exact number, but let's say it's $10,000. And the defense had said, we don't owe this guy a penny. We could have gone to court. It would have taken 2 years. We decided to arbitrate. We agreed to arbitrate. My client, I talked to my client, told him all about this. My client said, I'm great with this. Let's arbitrate. We're going to arbitrate. We go to the arbitration. My guy testifies. They bring in some people testify on their side. We submit briefs. We submit everything to the arbitrator. The arbitrator starts asking us questions before we're done. The other side goes, we don't think the guy deserves a penny. Give him 0. I say my client is entitled to $10,000 guaranteed, carve it in stone. That's the proof right there. Arbitrator looks at me and goes, Mr. Lehto, what about your attorney fees? I said, what about them? And he goes, do you have any on this case? I said, yeah. I said, but I'm not aware of any statutes that allow for recovery of my attorney fees. And I'm one of these attorneys who will actually tell a tribunal, if asked, what the law is, not what the law should be if I got to change the laws. So if a judge asks me, Mr. Lehto, is there a statute that allows you to collect your attorney fees on this case? If there is, I'll say yes. If there's not, I'll say no. So the arbitrator said, is there a statute for you to recover your attorney fees? I said, no, there is not. He said, how much are your attorney fees? It's $5,000. He said, okay, anybody else? Okay, we're done. I'll issue an award. About 3 days later, I get an award in the mail. Arbitrator awarded us $15,000. And my opponent called up screaming. He was livid. I could almost hear him screaming if I put the phone down and just listened to the window, and he wasn't nearby. Going insane. He goes, Steve, you are not entitled to $15,000. You know it. I know it. Will you stipulate to reduce it to 10? I said, if he'd rendered an award of 5, would you have stipulated to bump it up to 10? And he goes, no, of course not. I said, same answer. The guy goes, but you're not entitled to it. I said, no, you're misunderstanding how this operates. I got an arbitration award. I can now take it to court and convert it to a judgment. Does your client want me to do that or not? Because they can pay me the 15 right now, or I'm going to go get the judgment and chase them. It's your choice. Guy goes, no. He goes, I'm going to take this to court and appeal it. I said, yeah, I'm going to ask for my attorney fees in that too. There's a stretch on that one, but there are court rules that say I can get attorney fees on a frivolous motion. And the guy hung up swearing a blue streak. And I got a check in the mail about 3 days later for $15,000. And so those kinds of things can happen. And I know there's people out there right now are saying, Steve, that's unfair. You got a windfall. Well, it makes up for the other time I told you about where I had an arbitrator award less than either side had asked him for. And his final ruling was mathematically impossible. But that's what arbitrators do. They do what they want because they're both judge and jury. And so in this case, an arbitrator awarded the woman $5.2 million against the man who is known in these pleadings as the insured because he's got insurance through Geico. Geico is in federal court saying we shouldn't have to pay that. We'll see what happens there. But as of right now, the Missouri Court of Appeals in the Western District has ruled that that is a good judgment, and they're saying that she can proceed in her attempts to collect that. So we'll see what happens. I will update you. There will be further news on this. But as of right now, without question, this is the most requested story I've ever had on my channel. I can't thank everybody enough. Let's just put it this way. If you are a resident of the planet Earth and you were here yesterday, I thank you for sending me the story. Questions or comments, put them below. I'll talk to you later. Bye-bye.
Thank you for watching Lehto's Law. Mornings would be much better if they came later in the day.